19-0598, Guirguis versus Patel. Each side will have 20 minutes for argument. So we have a clock at the bottom of the screen, but you'll be responsible for keeping track of your own time. Appellant, you may reserve any amount of time that you want for rebuttal, but you'll have to keep track of that. We are recording the argument, so when you begin your argument, please identify yourself and your client so we can keep everybody straight when we review the recording. You'll be able to see how well you did in a few days. The argument will be up on YouTube. We've read the briefs and looked at the record. We've conferenced the case, so we're familiar with the law and the facts. So when you begin your argument, just launch right into what you want us to know and talk about. Counsel, you may begin.
Good morning, Your Honor. If it pleases the court, I'm Gregory Mell. I'm the attorney for the appellants Amir and Nancy Guirguis. Mr. Guirguis and his two sons are present with me and just listening to the audio in my office. Thank you and good morning, Ms. Weber. Thank you for the opportunity to present the oral argument today. When drafting the briefs in this matter, I was struck and somewhat nostalgic about the simplicity and beauty and clarity of the law. It reminded me of my first year in law school and some of the logic courses I even took as an undergraduate. The issues we're dealing with here are really exemplars of what I learned the first year of law school some 31 years ago, when we were taught the cornerstones of the law and how the use of logic provides very beautifully simple and clear results. There are some themes I want to quickly emphasize, and I also wanted to mention that I'm going to reserve 5 minutes for reply to Ms. Weber's oral argument. The joint pretrial statement, which is at the index of record number 72 at pages 9 and 10, sets out the elements that need to be proven for a fraudulent transfer. And it requires a finding of insolvency. Meeting the legal elements of a claim is a question of law, so we have a de novo review here. Again, in the defendant's counterclaimant's claim of fraudulent transfer, they were required, they had the burden of proof to prove that the Guirguises were insolvent at the time of the transfer or became insolvent because of the transfer or obligation. This is based on ARS section 44-1001 as stated in our opening brief and in the case law that's cited after that. In the present case,
counsel, I think there was testimony that the parties withdrew nearly all the funds from the account, and both LLCs owed almost $170,000 in obligations. That doesn't show fraudulent transfer.
No, Your Honor, because there was no insolvency that existed at the time of the transfer, nor was there any insolvency that existed as a result of the transfer.
Well, can insolvency be inferred from the evidence that Judge Howe was referring to? Could the jury have inferred insolvency from the fact that he took the remaining money out of that account when there were bills due and those bills were never paid?
Well, I'm not sure that the testimony was that the bills were never paid, but I'll address your correction directly. A finding of insolvency is a very technical requirement. The Transamerica case did a good job of describing it. And it says that a finding of insolvency depends on an actual analysis of assets and liabilities, a fact and figure balancing, rather than an inferred conclusion. And that's at Transamerica Insurance Company versus Trout, at 701 P. Second 851.
Well, could they have inferred, though, from the facts that they heard? I mean, it wasn't as if they said, we had some bills that needed to be paid and we had very little money left in the account. I mean, the amounts left taken out, the amounts left in the account, and the bills that were due were all facts in front of that jury, weren't they?
I'm not convinced that they were, Your Honor. If you look at what they said in their answering brief, they cited to the May 27th, 2019 trial transcript. And their only argument is that the appellees, quote, reviewed a bunch of vendor invoiced of credit requests, bills, essentially from creditors. And then in doing so, the testimony actually only discussed 2 bills from the creditors. So it's the insolvency of not of the company, Your Honor, from which the funds were taken. It's the insolvency of the party who conducted the transfer. And there was no finding that either Mr. Guirguis or Mr. Hanna were insolvent at the time of the transfer.
Why isn't it the insolvency of the company? Isn't that they're trying to keep this business alive, and if they have to take it back, they will be obligated to pay bills that are owed by the business? Isn't that their argument? And it seems like there's a showing that the hotel didn't have enough money to pay its bills.
Well, if again, the fact that there was money taken out of the accounts does not mean that there was not a continued cash flow. These were both fairly successful businesses until the tortious interference occurred. They were more than able to pay their bills, and the fact that some cash reserves were taken did not leave the company insolvent. The cash flow, the positive cash flow, continued on a regular basis. There's no finding to the contrary. It wasn't like this was just a company that stopped operating once the transfer was made. It didn't. It continued to operate, and bills were continued to be paid. Perhaps not all of them, but bills were continued to be paid. I think the record shows even after the transfer. And to answer your question is, why isn't it the insolvency of the business? Your Honor, Arizona law, that's a question, I guess, for the judges that set the precedents in the Transamerica cases and the Sacklin versus Kirsten cases and the Hay versus Duskin case. They say it's the fraudulent transfer of the entity or the insolvency of the entity or individual party who's trying to avoid its obligations. The aesthetic, for me anyway, the aesthetically pleasing example of the law here relates again to the equitable indemnity claim, and I'm skipping from your discussion about the fraudulent transfer back in order to the claims we've set forth in the briefs. The ruling in favor of the appellants on the tortious interference with business claim, as a matter of law, precludes relief on the equitable indemnity claim. It's a very simple and to my mind, somewhat beautiful exercise of logic, where you have unclean hands preventing equitable indemnity claims and the jury's ruling against the defendants and counterclaimants for intentional interference with business prospects, which dirties their hands, then they're prevented from recovering on the equitable indemnity claim. Now, in their
can't there be degrees of unclean hands? What if it's just slightly dirty hands? Why isn't that something the jury can just assess?
I guess they could, Your Honor. I'm not sure that's allowable, but yes, I think anytime you're in an equitable forum, there's some flexibility in that regard.
An absolute bar. You're suggesting that the finding that that they had some fault precludes a ruling the other way.
Yes, I am. And because, and more to your question, yes, there could be some flexibility in I guess, determining the degree of soil on the hand, so to speak. But in this case, in order to find a tortious interference claim, you have to meet some very specific requirements and demonstrate the existence of some fairly egregious intentional conduct. So even if you were right and there is some discretion given to the jury to determine the degrees of unclean hands, in order to meet the tortious interference with business tort threshold, the unclean hands are of a severe degree. You have to have intentional bad faith conduct. And so we would argue and respectfully submit that that was demonstrated here and that the degree of soil on the hands is more than sufficient to bar the claim here.
Counsel, did you raise this issue in your answer brief, or did you even ask for? I mean, how can the jury determine unclean hands when they're not instructed in what unclean hands means?
I believe the joint pretrial statement and the questions given to the jury that are referenced in the jury verdict minute entry does a decent job of demonstrating to them what they had to find in order for tortious interference with business relations to exist. In fact, the elements of the cause of action are specifically delineated in the joint pretrial statement.
Well, part of our problem is that your reply brief, after it's brought up in the opposing brief, doesn't give us any cite to the record of any kind, either to your answer, to the joint pretrial statement, to anything in the trial transcripts, to any of the jury instructions. Your response to their assertion that you didn't raise the claim of equitable unclean hands, I'm looking at your reply brief and there's nothing in here that cites me to the record. So I'm not sure what we should be looking at right now if you're going to cite to the record when you didn't provide that to us in your reply.
Well, that's one of the purposes of a de novo review here. You have the index of record before you. The joint pretrial statement, which we did cite in both our opening brief and in our reply brief.
Reply brief on this issue. There's no citation at all to the record in your response.
No, let me just see here, Your Honor. I believe I have it right here.
I'm on page 8 of your reply brief regarding appellee's unclean hands bars claim for equitable indemnity.
Yeah, I believe that the elements for the tortious interference with business were set forth at the joint pretrial statement, index of record 72 at pages 9 and 10.
Are the jurors given the joint pretrial statement?
It's my understanding that they are and that they were.
Well, that's not my understanding that the jury would ever be given a joint pretrial statement. So I understand you weren't the attorney of record in the trial, but I don't see anything in the record to show us that this unusual proposition of handing the jurors a joint pretrial statement, which contains all sorts of things that they wouldn't be privy to, is the case here.
I mean, it seems that the thing that the jurors need to know are instructions that would have the elements of whatever they would need to find.
Well, Your Honor, the fact that we didn't cite to the specific and jury instruction, which lays out the elements of the claim for a tortious interference with business claim, does not mean that you're precluded from reviewing those instructions on your own volition.
We're asking, were the jurors instructed in that manner?
It's my understanding that they were, but I can't cite it to you right now because I don't have the jury instructions in front of me. Let me see here. It's my understanding that the jury instructions, they used in large part the Rajis, and they would have and did include the elements of the claim for tortious interference with business relations and the issue of equitable indemnity. Here they are. The jury instructions. I'm just paging through down to the equitable indemnity claim. Which instruction were you interested in? The instruction on the tortious interference with business relations or the equitable indemnity claim?
You're arguing that the jury understood the elements of unclean hands, so wherever that is. If you'd like to provide that to us later,
okay.
Because
I would like you to address, at least briefly, if now or why your view that your client's personal guarantee was done away with by means of the deed in lieu of foreclosure.
Because of the very language of the deed itself, the deed in lieu of foreclosure itself, it uses language like the full and absolute release from all liability on any and all promissory notes, debts, obligations, costs, or changes. And then it says, secured either by the deed of trust specifically referred to in paragraph or by any other deed of trust or encumbrance. So,
yeah, but is a personal guarantee a deed of trust or an encumbrance?
No, but it's certainly one of the any and all liabilities, debts, obligations, costs, or changes.
What's the point of a personal guarantee if you already have a lien against the property securing the promissory note? It seems odd to have the property also cover the. Why would you get a personal guarantee at all if returning the property also does away with the personal guarantee?
Well, it's a choice of remedies question, Your Honor, and the creditor can either seek to enforce the personal guarantee and leave the property alone, or it can exercise its right or attempt to acquire a deed in lieu of foreclosure, which results in a merger where the mortgagee's interests or the creditor's interests in the fee title come to be owned by that person. And so it's a choice for them. And the fact that they choose one doesn't mean that the other is still available, especially when the choice that the remedy that they've chosen.
Is there something in the personal guarantee that specifies that if they choose to foreclose on the property, the personal guarantee goes away?
No, but it doesn't need to say that because they were the ones that negotiated the deed in lieu and foreclosure. They're the ones that presented it. They chose the language, and they could have easily chosen to exclude the personal guarantee from that release. And instead,
I did have that question. The reply brief seems to say the appellants prepared, that your clients prepared the deed in lieu. Is that did I read that wrong in the reply brief?
I don't believe that our reply brief said that. But let's assume that they did prepare it.
Do you know who prepared it?
This would, I believe it was the appellees, the counterclaimants that suggested the deed and presented a deed in lieu of foreclosure.
The reply brief says it is undisputed that appellants drafted and presented appellees with the deed in lieu of foreclosure to carry out the transfer of all interest in the property back to appellees.
I stand corrected, but even if that's the case, this was negotiated at arm's length, and the appellees could have easily said, we want to add language in there that excludes their rights to enforce the personal guarantee. And they didn't do that. They negotiated very comprehensive and global language regarding the release. I don't think it could have been any more comprehensive than it was written.
Well, it could have said it does away with any personal guarantees. Wouldn't that have been more comprehensive?
It did do that when it said it does away with all liabilities, debts, obligations, costs, or changes, and any encumbrance whatsoever.
So you're just saying all liability, and the grantor are the individuals and not the hotel.
Yes, and in the section,
Just the deed in lieu of foreclosure, if they're foreclosed, they're not foreclosing on individuals. They're just getting the deed back from who held the deed.
well, they're all not only getting the deed back, but they're also releasing all promissory notes as well related to the deed. I believe that particular transaction had to do with the A&D Properties Agreement, which would have been the Knights Inn motel. And I'm at about the 25-second mark, so I guess may I reserve 30 seconds after Ms. Reber is done?
Yes. We'll be generous and give you a minute.
Thank you, Your Honor.
Thank you. Ms. Weber.
Thank you, Your Honor. May it please the court, Lindsay Weber of Polsinelli appearing for the appellees. Your Honors, everyone here can probably agree it is an uphill battle to overturn a final judgment rendered after a jury verdict. Here, appellants waited more than a year to file this appeal and have delayed numerous times since then. We are currently now more than 2 years beyond the date of the judgment being appealed. But in addition to laches, the merits of this case and applicable Arizona law all support this court upholding the jury verdicts and affirming the judgment entered by the trial court back in July 2018. I'd like to start today by addressing the assertions set forth in the reply brief filed by appellants, including some of the points Your Honors have addressed, and then discuss the awards in favor of appellees, including the award of attorney's fees as the prevailing party in the trial court. So first, with respect to the reply, appellants assert that, quote, where the jury awarded appellees 0 damages on a claim, the appellants are the prevailing party. You'll find that in the reply at page 1. But yet appellants continue on to ignore this alleged proposition when continuing to assert that they are somehow the prevailing party under the totality of the claims and counterclaims addressed in the litigation. Throughout the opening and reply briefs, appellants create mathematical comparisons without any citation and in some cases direct contravention to the actual record in the case. The record shows that appellants sought in excess of $1 million in damages and were awarded, before accounting for the offset, less than 5%, or 4.8% to be exact, of the damages sought. You'll see page 21 of the answering brief and footnote 6 for record citations, including transcript day 4 at page 230 to 231. As set forth in the final judgment at IR 131, appellants were not awarded any damages after offset and were held liable to appellees in excess of $400,000 net. No matter what calculation appellants wish to construct, it does not change the fact that the trial court properly determined, based on the jury verdicts, damages awards, and the record in the case, that appellees were the prevailing party. With regard to the case law and legal authorities cited in the reply, they are neither on point nor relevant to the claims and issues in this case. First, appellants' repeated citation to bankruptcy appellate case law is inapposite. For example, the Diamant v. Hansen case involves an analysis of fraudulent transfer law under the Bankruptcy Code and California law, not Arizona law. And in the Weinberg case cited in the reply, the court there specifically noted that there was a complete lack of any evidence in that record regarding the debtor's failure to make payments as they became due, which is readily distinguishable from the facts and record in this case, as pointed out by Your Honors, where the expert testimony provided on day 4 of trial confirmed that plaintiffs had habitually and consistently failed to make payments on their debts and obligations as they became due. The reply further appears to...
Counsel, can you address the issue that it has to be the insolvency of the person and not the insolvency of the entity? I'm confused about why that would be the case.
Certainly, Your Honor, I will do my best. As Your Honors pointed out, the record does reflect that as things were starting to go poorly for the current operators, which were the plaintiffs in this litigation. They, in fact, did clean out the bank accounts of these entities. And that is part of the fraudulent transfer, and that is actually the amount of the fraudulent transfer that the jury awarded. So the insolvent
You're just talking about it's one $9,000 withdrawal of funds. Is that what you're saying? Cleaned out the 9,000. Opposing counsel suggesting that money was still coming in and bills would continue to be paid. You're just saying the 9,000 cleaned it out, and that's what rendered that was the fraudulent transfer.
That appears to be the amount of damages, yes, that the jury honed in on, because at that time, the entities were not, in fact, paying their bills as they became due. The expert noted that there were between 1 and 7 months overdue for various bills and invoices, including $8,000 due to the Arizona Department of Revenue and $24,000 due for property taxes. It wasn't as though this was a single bill that wasn't being paid. The plaintiffs had habitually and consistently failed to pay their debts as they became due. And whether or not there was additional income coming in after that point, at the time of the fraudulent transfer, there was a demonstrated insolvency on the part of the transferor entity to the transferees, the plaintiffs. The reply further ignores that ARS 44-1002 provides alternative and independently sufficient definitions of insolvency, and that the statute actually here provides a presumption in favor of appellees on the insolvency issue, where the evidence presented at trial demonstrated that appellants were generally not paying their debts as they became due, and therefore under the statute, they are presumed to be insolvent. And that's ARS 44-1002 subsection B.
And so we're talking about the entity and not the persons involved, correct?
In that instance, correct, Your Honor. Here, the entity was the transferor of the fraudulent transfer, and the plaintiffs were the transferee. Okay. Now, at the time of the transaction at issue, or I should say at that time period, the transferees were also in charge of the transferors. They were the folks running those entities and those hotels at that time. So there may be some confusion as to which role plaintiffs were acting in during the course of the fraudulent transfers, but I don't believe there's any question as to the insolvency of the transferor entity at the time of the proposed transactions here. In addition, the expert also testified on day 4, and this is in the transcript at pages 58 to 59, that even after that time, non-sufficient checks were coming in and past due notices continued to be received. And in total, as Your Honor pointed out, there was over $169,000 of unpaid and past due outstanding obligations, which had to be paid after plaintiff emptied out the bank account, leaving no funds to pay the overdue expenses. So in short, Your Honor, the record amply supports the jury's determination of insolvency at the time of the fraudulent transfers. The reply filed by appellants further makes the unsupported claim at page 8 that the answering brief admits various propositions that are in fact no way admitted in the answering brief, which is likely why there is no corresponding citation to any specific alleged admissions by the appellees.
Counsel, could you address the personal guarantee issue?
Certainly, Your Honor. With respect to the breach of contract claim that the jury awarded appellees $75,000 in damages on claim 13 for breach of contract. Appellants' arguments regarding the breach of contract award appear to rely on a deed in lieu that was executed on behalf of a borrowing entity, Bell Hotel, but did not release or otherwise absolve the appellants who unconditionally and irrevocably guaranteed the obligations owed to appellees. And you'll find that at Trial Exhibit 8 that was admitted and is in appendix at App 2 through 8.
But why doesn't the language, the full and absolute release of the trustor from all liability on any and all promissory notes? You're saying that all liability doesn't also encompass a personal guarantee?
I am saying that, Your Honor, and it's a two-part response to your question. First, Arizona law is clear that a guarantee is a separate and distinct obligation from the underlying note. You can look to the Provident decision at 180 Arizona 464, from the Court of Appeals back in 1994 and the progeny since then.
But even if it's separate, this says any and all promissory notes, debts, or obligations. So we'll assume it's a separate obligation, but this is saying a release of any and all debts and obligations. Why not specify, but not the personal guarantees signed by the parties?
Understood, Your Honor, because first of all, I don't believe that is necessary. I think Arizona law establishes that guarantee obligation, and particularly the broad, unconditional, and irrevocable guarantee set forth in this document, remains in place. But secondarily,
you would agree that if the deed in lieu had said the full and absolute release of grantor from all liability and from all personal guarantees, you would agree that takes care of any obligation under the personal guarantee?
If this had specifically included the guarantees and most likely also identified who those guarantors might be, perhaps I think as a matter of contract they could have.
But then but doesn't that leave us with the problem of saying, is this language broad enough? And certainly your client could have was in a position to say, well, no, this is, when it says any and all obligations, why not step in at that point and say, except for the personal guarantees that have been provided?
Because, Your Honor, the first part of the sentence that you're quoting from takes care of that problem for us, because it says that it's a full and absolute release of grantor and grantor only. In fact, this entire document only discusses the grantor's obligations, and the grantor was the entity, the borrowing entity. So in addition to just the premise of Arizona law that makes the guarantee separate, this deed in lieu does not affect the guarantee because it is limited, including in the paragraph Your Honor has been citing from and cited in the reply brief, only to a release of the grantor, and the grantor is not the appellants.
The grantor is listed as Bell Hotel. Who is listed on the document as the grantor?
Correct. It is Bell Hotel, Your Honor. It is in the first 4 lines. It is a defined term in the prior part of the deed in lieu.
Counsel, my understanding of general Arizona law is you can choose to foreclose on the property, or you can sue on the note. If you choose to foreclose on the property, why would the guarantee of the note survive?
Because, Your Honor, there is an ability still, even through a standard, and we usually discuss judicial foreclosure or deed of trust, non-judicial foreclosures. Even in those areas, there is an ability to preserve liability, even if you choose to elect through one of those foreclosure procedures. I will be frank, there is less case law on the third and less discussed option, which is a deed in lieu of foreclosure. It generally does not fall under either of those 2 aforementioned categories, where we have some case law on how a creditor can preserve those rights, even though they are performing a foreclosure activity. But again, here, the deed in lieu itself does not in any way affect the guarantee obligations, and the guarantee itself makes very clear that any election of remedies or any other actions taken do not affect the obligations under the guarantee. And so there was more than a reasonable basis for this jury to determine that on a $300,000 guarantee obligation, an award of $75,000 was a reasonable award for the damages incurred, again, for the obligations guaranteed irrevocably and unconditionally by the appellants. Your Honors also asked quite a few questions regarding the Equitable Indemnity Award. And again, the jury awarded damages of $169,761 for equitable indemnity based on appellants' failure to pay obligations that appellees were then forced to pay. As set forth more fully in the answering brief, appellants waived their arguments regarding any alleged unclean hands defense by failing to plead or otherwise raise it as an affirmative defense in the trial court proceedings. And to follow up on one of Your Honor's questions from earlier, I do not believe the jury was provided a copy of the joint pretrial statement, and nor do I believe that the transcript would reflect that. In addition, appellants way of
Counsel, were the jurors instructed on what they would need to find if they were to consider unclean hands?
I do not believe there were any jury instructions regarding unclean hands, Your Honor, and the final jury instruction is located at IR 103. And no, I do not believe that instruction is in here. But in addition, on top of the unclean hands argument, appellants appear to be proffering an inconsistency argument, but they've also waived that by failing to follow the post-jury verdict process and procedures that are set out in Arizona Rule of Civil Procedure Rule 49. And where a party fails to raise an issue with the trial court prior to dismissal of the jury, that issue is waived. And we look to the Trustmark case, 202 Arizona at 543 for that proposition. In addition to the dual waivers by appellants through their repeated failure to raise any issue regarding the award for equitable indemnity, appellants' underlying premise also fails because the alleged interference that plaintiffs asserted in count 4 had nothing to do with the bills and past due payables that were regularly ignored and skated by the appellants. Even a cursory look at those jury instructions drafted and submitted by appellants shows only that the contract alleged to have been interfered with was a singular contract between plaintiffs and Rocky Francis. There is simply no connection between any alleged wrongful conduct resulting in an award on count 4 and the equitable indemnity award against appellants. And there's nothing in the record because there is no connection there. With regard to the fraudulent transfer and insolvency, again, remembering that the jury awarded $9,000 based on a verdict that found appellants transferred funds that they were not entitled to without receiving reasonably equivalent value and during a period of insolvency. The appellants do not challenge necessarily, nor could they, the findings regarding transfers without a reasonably equivalent value based on the trial testimony demonstrating that plaintiffs cleaned out a bank account right before they abandoned the operations. And you'll find that testimony in the transcripts at day 4, page 56, line 12, through page 57, line 20. And in fact, you'll hear the plaintiffs themselves on day 2 at page 197, lines 4 through 9. Instead, appellants focus solely on the insolvency determination and attempt to convert that analysis into a subsection A balance sheet test while ignoring the subsection B of the statute, providing for the failure to pay debts as they become due. Your Honors, I'd like to briefly address the attorney's fees award. As we know, the decision to award attorney's fees under ARS 12-34101 is discretionary, and this court should give deference to the trial court's determinations in this regard. We know that if there is any reasonable basis to uphold an award of attorney's fees, this court has long determined that the trial court's discretionary award should stand. And we look to the Lieu versus ING Investment Management 240 Arizona 158 decision. The discussion in paragraphs 8 through 10 of the Lieu decision are instructive regarding the arguments proffered by appellants and confirm that the award of attorney's fees is proper and appropriate under the circumstances of this case. Here, as further addressed in the answering brief, there was ample basis in the record for the trial court's determination that under the China doll factors addressed by the parties, the award of approximately 80% of the fees and expenses sought by appellees was reasonable as the prevailing party under the totality of the circumstances of this case. And there is no basis, and appellants have provided none, to disturb the trial court's award of fees to appellees. And it is important to keep in mind that there were numerous claims and counterclaims alleged by both parties to have arisen from contract. Appellants were awarded 0 on their contract claims, as appellees successfully defended against those claims. So both as the prevailing party on appellees' affirmative contract claims, but also as a successful defending party, appellees were entitled to recovery of their attorney's fees. And that same principle should follow through to this appeal, Your Honors. As requested in the answering brief, appellees are entitled and are seeking reimbursement of their attorney's fees incurred in this appeal. Appellants decided to wait more than a year to file this appeal and have offered virtually no grounds to overturn the jury verdict and judgment entered in favor of appellees. This appeal was brought in an untimely manner and without basis, and because appellees are the prevailing party in a contract dispute, An award of attorney's fees incurred in the appeal is appropriate as well. In conclusion, Your Honors, the evidence before the trial court supports the judgment in favor of appellees. Appellants have provided no basis in fact or law to overturn the verdicts and judgment rendered more than 2 years ago in the trial court. The award of attorney's fees was amply supported by the record in this case and was properly entered in the trial court's discretion. For all of these reasons, and as further set forth in the briefing submitted to the court, appellees respectfully request that this court affirm the trial court and award appellees their attorney's fees and costs incurred in this proceeding. I'm happy to answer any questions. It looks like I have a little under a minute. Thank you, Your Honors.
Thank you.
Thank you, counsel. We appreciate your argument. Mr. Mel, you'll have a minute for rebuttal.
Thank you, Your Honor. I'm perplexed by the claim that this appeal is untimely. It was the fact that the defendants failed to reduce the ruling on the motion for new trial to a judgment was not the plaintiff's fault. And once it was reduced to writing, we filed a timely appeal. With regard to insolvency, Ms. Weber talked about the business doing poorly. A business doing poorly does not equate to insolvency, and the Transamerica case sets forth very clearly that insolvency exists when the present fair saleable value of assets is less than the amount that were required to be paid. Not all bills were 1 to 7 months overdue. There's not any evidence of that. And inability to pay is different than failure to pay. The fact that they failed to make timely payments doesn't mean that they were insolvent. Hotels are businesses with large expenses, and $159,000 is not insurmountable in terms of debt. Finally, with regard to the deed in lieu, if you will look at page 1 of 7 in section 1A of the deed in lieu, it says that it is providing for the surrender and cancellation of the promissory note or notes or other evidence of debt secured by the deed of trust. It's in section 1A on page 1 of 7. So therefore, if the promissory note was canceled and surrendered, there's no note that exists any longer for the personal guarantee to apply to. Thank you.
Thank you, counsel. We appreciate your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We'll stand at recess. Thank you.
Thank you, Your Honors.
Thank you, Your Honors.